You can start.
What is your name?
Jeff Kenny.
What is your occupation?
I am a UAW International Representative.
Approximately how many arbitrations have you handled in your career?
Approximately 50.
How do you investigate a typical disciplinary matter involving a union employee?
Generally, I meet with a grievant. I talk with the witnesses, the union representative, the steward, and then I talk with the company and their representatives and witnesses.
What do you think are important things for a union steward to remember before going into an investigatory interview with an employee who might be in trouble?
Ideally, I think they should go in with an open mind, understanding they're only going to get a partial part of the story, that the whole story comes when the investigation is complete and you find out what both sides have said. I generally make sure that they've got a notepad or a fact sheet with them that allows them to keep track of what's happened and to listen instead of doing all the talking. They should spend time listening so they can weed out the facts.
We conduct mock arbitrations at Grand Valley. How would you advise students to prepare their witnesses for arbitration?
Well, initially, I would say that once you've established who your witnesses are, that they should sit down and go over what the answers to the questions are going to be and do it repeatedly to make sure that everybody's clear on what's expected, and to make sure that they've got people that are going to give the facts, the absolute truth. Arbitrators have a keen sense of finding out if people are giving false testimony. So generally, I make sure I try to weed out those people and get witnesses who can give me specific facts, dates, times, and what's happened. And once they've been interviewed, I just want to make sure everything they've said is true and accurate. So I prep them by continually asking the questions to make sure I get the same answer every time.
How would you advise students to prepare their opening statements for arbitration?
Most arbitrators that I've found over my years have always liked short opening statements. They want the facts, they want the specifics of the case, they don't want to hear about long-time histories, and I would tell them that their opening statement must be followed by what their request is in the arbitration, what the resolve or the settlement to the grievance should be.
What would you tell students are the most important things to remember when preparing questions for the arbitration?
Don't ask questions you don't know the answers to. Make sure that you are very clear that the answers are consistent. You should always line up your witnesses in an order that's most advantageous to your case. Ideally, the grievant should go first, but it's not necessarily always the best way to go. Sometimes you want supporting evidence prior to the actual grievant. But basically, I just want to make sure I've got witnesses that are under control. If they can't control their emotions, I don't bring them in as witnesses.
What would you warn students about in regards to cross-examination of the other side's witness?
Best thing, since you never know what the opposing side is going to ask, you should take good, clear, concise notes of the questions that are being asked and the answers to make sure that you've established a list of questions in your cross-examination. 9 times out of 10, you don't know what they're going to ask, so you don't know what to expect. And that's the way I always ask them, and always try to keep the answers in the cross-examination to yes and no answers. Don't allow a lot of elaboration on their part. That's their job to present their case, not for me to dig it out.
Do you typically give a closing argument, or do you send the arbitrator a closing brief?
99.9% of the time I do a closing brief. If I am absolutely certain that I have the case won, I will do a closing argument and try to get a bench decision. But most of the time, the vast majority of the time, I do briefs. It gives me an opportunity to put my thoughts all down on paper, cover all the facts that I've gotten through my investigation, because it's realistically it's your last chance with the arbitrator to present your case. So you want to hit everything you can to support your position.
If you give a closing argument at the hearing, what main points do you think are important to make in your closing statement?
Just to reiterate your initial points, your issues, and make sure the arbitrator hears them clearly, that this is the substance of your argument, and again to make sure that he is absolutely clear on what your expectation of the settlement is.
You must have read hundreds of arbitration awards in your career. What do you look for in a good written arbitration award?
That the arbitrator got a grasp on what my argument was, whether I did something wrong or he didn't understand the way it was presented. I look for issues brought up that maybe were not presented in the arbitration, to give me an opportunity to file a protest with the arbitrator that they weren't brought out as part of the evidence. Generally, I can tell that in the post-hearing briefs if they're going to present an argument, but if something's brought out that wasn't covered in the arbitration, it's not supposed to be a part of how the award is written.
What factors do you think makes a good arbitrator?
Well, a history of fair awards, not necessarily win or loss. A good grasp, a good ability to retain the information during the arbitration. The arbitrators that tape record, I actually appreciate more than the ones that take notes. I believe the tape recording gives them time also to absorb it. I would love to have a union advocate as an arbitrator, but it seldom happens when both parties have histories on arbitrators. Generally, both sides are fighting to get a neutral person that isn't good for either side. But in the joint selection process, it's almost impossible to get one that's all pro-union.
What additional advice do you have for students preparing for an arbitration hearing?
Be cautious about the way you select an arbitrator. Look at your case and look what criteria you may need to have that decision made. Some of the things you have to look at, depending on the case, might be their experience in that issue itself, age, gender, their background history, depending on the case. I think they should know their case and their witnesses completely. They should do their investigations thoroughly. They should have fact sheets with them that help them collect up all the information, who their witnesses were, when they talk to people. Arbitrations generally take 6 to 8 months to actually schedule, and a lot of information can be dropped. Avoid chaos in the hearings. You don't want everybody talking. You've got a union representative and a company representative. Unless you're called to the stand, nobody else should be talking. You got to remember that every grievance doesn't have to go to arbitration. There's nothing says it does. If the facts don't support it, it shouldn't go. Know as much as possible about your arbitrator. Present your case professionally and courteously. I believe that carries a lot of weight, that you're respectful of the arbitrator, the company, their witnesses, everybody, and attitudes get picked up real fast. Never allow a witness to lie, ever, under any circumstances. If they can't tell the truth, they shouldn't be a witness. Make all of the information requests to the company in writing, and request that you get all the information you need to support your case, and present every case like you absolutely believe you're going to win, or it won't get there. Arbitrators are it. They're final and binding, and you don't get do-overs because you made mistakes.
What is your typical day like?
In servicing, I generally am involved in anywhere from 2 to 4 meetings in a day. Meeting with local unions on different steps of the grievance procedure, investigating and arguing the grievances. In a lot of cases, a termination hearing might be slotted in, and I schedule my arbitrations as they come up, so there could be an arbitration as well. It varies from day to day, but I can't make long-term commitments on a lot of things because the average rep services 17 plants on an average 6,500 people to a service assignment, and all of them believe that their issues are more important than any others, and they want your service immediately. So your schedule's at their whim. So you can be gone and have vacation planned, and your vacation is over.
Thank you very much.